Thank you, Kathy, and good afternoon, everyone. As Kathy has said, welcome to our Tuesday webinar series. We're going to try to get to as many questions as we can today. We've got a lot to cover. On a positive note, some of you may recognize that I'm in our office in Syracuse. We're in a we're reopening phase, and we're able to be open for some in-person operations. So we're thrilled to at least have some progress as we try and move back with a new normal. So without further ado, let's turn this over. We want to start today with Kate Schimmelwick. Kate is going to talk about the payroll protection program and some things to focus on as we proceed with reopening. Kate, take it away.
Thanks, Pete. So with so many borrowers being right now in the thick of their 8-week covered period and either an essential business so they've never shut down or have already completed phase 1, are in phase 2, or in phase 3 or 4 and preparing to be opening in a coming phase, there's a lot of considerations right now for the PPP funds, how to use them, and things that really borrowers should be thinking about. So first off, I know we've talked about this on previous webinars, my colleagues have talked about it, but it's crucial, and that is documentation. Right now, you do not want to be in a situation where when you're applying for forgiveness later, you're trying to chase down documents, you're looking for documents, you're trying to talk to third party, like payroll companies, trying to get payroll records, you're trying to remember why you made a certain decision or what the circumstances were later when you're applying for forgiveness. So right now, maintaining your documentation while you're reopening is absolutely crucial. With the forgiveness application, there's really 2 buckets of documentation that borrowers need to be mindful of. The first bucket is going to be the things that you're going to have to submit when you actually have the application at the onset initially. So those are going to be things related to payroll expenses. So those could be your bank statements, it's going to be your payroll service provider statements, tax forms, receipts, and other statements indicating contributions to employee health care costs, insurance costs, and retirement plans. It's also going to be documents related to FTE counts. And it's also going to be documents related to your non-payroll expenses. So things like your leases, your receipts, canceled checks, invoices, statements, all things like that. Okay. The second bucket of documentation that you should be maintaining right now and gathering is going to be things that the SBA or your lender may ask for either while they're reviewing your forgiveness application or later during an audit. So again, those are going to be documents supporting your salary caps, documents indicating who your employees are, and the de minimis exception. So I talked a little bit about the de minimis exception last week, and that is the exception for FTE headcounts. So as a quick recap, that is going to apply in a situation where an employee voluntarily asks for a reduction in hours. It's going to apply in a situation where an employee is terminated for cause. It's going to apply in a situation where an employee refuses to come back to work after they have received a good faith written offer from the employer to return to work at the same hours and pay that they were previously earning. Okay, it's also going to apply for voluntary resignations as well. So in order to claim this exception on the forgiveness application and not have your FTE headcounts have a reduction for those headcounts for those situations, borrower is going to have to go and maintain documentation regarding that exception. We've received a lot of questions regarding this exception in the past couple of weeks. And last week when I spoke about it initially, I had indicated that the SBA was going to issue new guidance on it. Particularly the requirement that an employer, if it wants to claim this exception on their forgiveness application, that they would have to let the local unemployment office know that an employee refused to come back to work and declined the offer. that the employer had made. As of today, there's been no additional guidance on this issue issued by the SBA yet. Obviously, this particular exception is incredibly important right now. With reopenings, employers are making decisions about bringing employees back from furloughs. Now that they're looking at reopening or have reopened, employers are looking at questions regarding that they've been previously paying employees to sit home, and now are asking them to come back into the workplace. So this is a really important exception right now that employers should be thinking about and documenting. And again, we're still waiting on more guidance about some of the issues. Now, while the SBA has not given us a whole lot of guidance in the past week, it's been very minimal on what we've received, there has been a really big development in the program. So late last week, the House did pass the Payroll Protection Flexibility Act. It's very important, though, to note that this is not law. Right now, it has passed through the House, and it is sitting in the Senate. When it passed through the House, it was passed with an overwhelming majority. However, right now, it is sitting in the Senate. Mitch McConnell yesterday indicated that he will be putting it for a vote in the Senate. There has been some stuff that has come up with various senators questioning some of the things in the act. So we don't know yet. We don't know if it's going to pass in its current form. We don't know if it's going to pass with some changes. And we don't know if it's going to pass in its current form, and there'll be more administrative guidance from the SBA and the Department of Treasury to then weed through to better understand the provisions. However, right now during the reopening phase, businesses really should be still familiarizing themselves with the changes in the Act and the new requirements. However, they should not take action yet for all the reasons I just said. It hasn't passed yet. We don't know what it's going to look like when it passes. Every business's circumstance is different. Borrowers are in different parts of their 8-week period right now. Borrowers have different business needs, and borrowers are in different phases of reopening. So every business is different. Okay. It also raises more questions. Again, this is probably going to be where the SBA guidance will come into play and be key. Just reading through the changes, which I'm going to get to here in a minute, there's a lot of new questions that are raised. And until we get answers to those questions and how that may impact a business, again, businesses should not take action until we have answers and the act is passed. But they should familiarize themselves with the requirements, maybe start thinking about how the use of their funds may change if it's passed. So without further ado, let me give some quick key points here about what changed in the Act. So first, right now the covered period is 8 weeks to use funds. That will change if the Act passed to 24 weeks. Obviously, this is exponentially larger time period to be using funds. It also changes the SBA's requirement that 75% of the funds be used for payroll expenses. It changes that down to 60%. So that means 60% payroll, 40% non-payroll expenses. This is another big change if it goes through. It changes the repayment term from 2 years for amounts that are not forgiven, and it increases it to 5 years. Obviously, this is a very borrower-friendly change, and it would also increase the deferment period from 6 months up to a year for repayment terms. Most interestingly, it creates more FTE exceptions. So, for example, there is an exception if the bill passes in its current form, there will be an exception for an inability to rehire employees. There will be an exception for an inability to rehire an employee at the same qualified level as somebody who had previously left. And there is an exception for an inability to fully staff your business at pre-pandemic levels based on guidance and regulations and requirements of the CDC, health departments, OSHA regs, that sort of thing. So a situation where a business can't return to capacity because there's not enough space to socially distance people. So those are some of the big highlights, the quick points in this new legislation, if it passes. That during this reopening, obviously the things that I just talked about are going to have big impacts on businesses and how they use their funds and their reopening plans. Again, though, it has not passed yet. We don't know what it looks like when it will pass, but it's something for employers to start thinking about, having in the back of their heads, in case it does. But right now, it's important not to take any actions that may hurt a borrower later on if something doesn't pass. So that's the developments right now for the PPP program in the reopening phases and things to be thinking about. And if and when the bill passes and when the SBA issues new guidance on some of the other questions that we've been waiting on, we will be issuing updates here from Bond. All right, thank you.
Thanks, Kate. It's a lot to follow and it's a lot to keep our eye on. And I know it's been constantly changing. Sounds like potentially more change in the offing. So I'd like to turn now. We're gonna do two different views on the reopening and a couple of different perspectives. We're gonna start with Hermes Fernandez, who's a member in our Albany office, and there certainly have been a lot of questions, and Hermes is going to try to clear some of those up. Hermes, take it away, please.
Thank you, Pete. I'm off mute. Yeah, I've seen over and over, we've seen various questions come from various people, and there seems to be some issues that are repeating themselves, some questions that keep coming up. I'm going to try and clarify some of those issues. The first one I want to talk about is counties and county executives, because we saw quite a bit of this in the last few days, and I've had people bring this up to me myself. Let me explain a little bit about the structure here. Counties are creatures of the state. They have no authority other than that granted to them by the state. That's different than the federal system in which the states gave power to the federal government. Counties have no independent jurisdiction or authority. Some county executives have announced restrictions no longer apply in those counties, and that they are in which they are the county executives. That's political grandstanding. It has no legal authority. If you are operating a business or just conducting yourself in a county where a county executive has made a statement like that, you follow that county executive's statement at your own risk. The county executive may be withdrawing his enforcement or her enforcement apparatus from enforcing these rules. State governments still can enforce. Your customers, your employees, your competitors still can make complaints. So beware of following pronouncements from county executives regarding these phases and the COVID-19 restrictions. Another one I've seen constantly come up, and we've talked about this repeatedly, which either says that we are very poor teachers or some of our patrons are poor listeners. Reopenings happening in phases, right? Once you are announced to have a reopening, that doesn't mean everything is open. That means only those items or those businesses, those activities that fall within the particular terms of a phase are open, right? And we've got 4 phases. Pete's sitting in the Syracuse office, phase 2. You 5 regions that started earlier, you were in phase 2. I'm in Albany, we're still in phase 1. Phase 2 starts tomorrow. I saw many people in Albany heading to offices today because they heard phase 2 starts tomorrow and they're jumping the gun. New York City's still not in any phase at all. Essential businesses, we've talked about this before, but if you are an essential business and your geographic location enters a reopening phase and your business falls within the broad category for that phase, your rules change. You now will move from essential business with only the rules that apply to essential business to the essential business rules to the rules that apply for all businesses within the phase in your geographic area. So that means you are going to have a plan. You are going to have to review the plan documents that are on the Empire State Development Corporation website. You're going to have to read those, understand those, and submit an attestation that you have put together a plan. You keep that plan in your offices. but you must submit a plan. So the rules change. It doesn't matter that you were previously open, the rules change. Gatherings. The limit is 10 people, right? That's statewide now, whether you're in a phase or not. Gatherings of up to 10 people are now permitted. This is not a loophole. This doesn't mean that when you reopen a business, or you can reopen a business with fewer than 10 people, right? This is social gatherings, this is political gatherings, this is religious gatherings. It doesn't mean that you can say, I'm going to compartmentalize my business and have 10 people in Department A and 10 people in Department B and 10 people in Department C, right? That is not how this works. The same is true for any other kind of activity. This is simply social gatherings. You can't simply group people off in tens and say, I've met the rules here. The limit is 10. Masks, face coverings. Employees and contractors of your businesses must wear masks, right? They must wear face coverings. In fact, they must wear all personal protective equipment that's necessary to maintain the safety of your work site. Face coverings and masks are not required of of customers. They are strongly encouraged. You are required to maintain a safe workplace. You are required to maintain the public health requirements. The guidance documents out there, even though the executive order says businesses have discretion on whether employees are to wear masks, the ESDC guidance pointedly reminds businesses that you are to follow the public health guidelines. And there are actually other documents, I think, that incorrectly state there is a requirement that customers wear masks. The discretion that a business has regarding allowing a customer to enter without a mask is really intended to avoid circumstances where there could be a blow up, right? You may have a circumstance where you ask a customer to leave. You're going to be in best circumstances where you make masks available to customers. They will not be completely required, but at the same token, you do not open your business and simply tell people, hey, we're a mask-free zone. That's not what the discretion is, right? It's discretion. This is really a one-off. Screening. When you are opening your businesses, when you're opening your activities, you must screen employees and contractors. Screening cannot be presumptive, right? You can't simply put out a list of questions and assume because you don't get responses that means people are saying, no, I'm okay. No, I don't have a temperature. You actually have to get responses. You are charged with reviewing those responses. Records that you have reviewed the responses must be maintained. The results themselves are not to be retained. There is not a requirement to screen customers. We know many businesses are starting to do that. Retailers are doing that, but you are not required to do that. The lack of specificity of these rules, which we hear many people complaining about, we complain about, right? They are written in general terms. They become more specific as we're seeing more details come out for particular businesses and industries, but they're not very specific. They have to be read along with the spirit of the rules. I like loopholes as much as the next lawyer. In fact, I like loopholes more than most lawyers do. But this is not the time to be looking for loopholes. This is the time for looking to abide by the spirit of the rules. And the reason for that is complaints. It doesn't matter where they come from. The complaint can still be regarded as legitimate, whether it comes from an employer, a customer, another employee, the competition. State government is continuing to review complaints and taking actions on them. And my final point on all of this is, don't expect this to end soon, right? Whether you're in phase 1, 2, not in a phase at all, maybe we get to phase 4 by the 4th of July in your particular region. We're going to be living with these rules for a long time. Pete mentioned new normal when we started this. That really is the phrase. It's going to be new normal in July. It's going to be, we're sick of this normal in September. Hopefully we're not sick ourselves. We're just sick of this normal, but expect this to go on for some time. With that, Pete, I can conclude.
Hermes, thanks. And you know, I prefer to think it's not that we're not communicating well or our clients and friends are not. This is complicated.
This is complicated.
And I think your advice is good advice to just, you know, we got to kind of consider where we are. You know, it's interesting to me gatherings are sort of outside of everything. Then there's the essential businesses. Then there's the phases. There's also the regions. It just makes it very complicated, especially when people are reading, in the popular media or other places about reopening as if it were, sort of one unified concept rather than kind of a fluid concept that has to be looked at depending on your business and your area and your time.
Yeah, well put.
Okay, so more reopening because I think it's really on everybody's mind. And Katie Schaefer, a member in our Syracuse office, has been providing us with a series of updates here. And Katie's going to talk to us a little bit about where we are. I think adding a little more flavor to some of these reopening questions that Hermes has teed up. Go ahead, Katie. Thank you.
Yeah, thanks, Pete, and thanks, Hermes. That's a really great lead-in because what I want to kind of start with is just to take a few minutes and recap for everyone where we are in reopening, because understandably so, it's pretty confusing at this point. There's a lot of factors at play here, and there's a lot of start and stopping and changing of rules as they go along. So I think it's kind of helpful to just kind of back up a step and make sure we're all on the same page. And I'm kind of a visual person, so I think looking at this map that we've all probably seen 20 times in some ways is really helpful as we're talking about the regions. So right now we have 6 regions that are in phase 2 of the reopening. That's Central New York, Finger Lakes, Mohawk Valley, North Country, Southern Tier, and Western New York, which was just announced today. The capital region is expected to enter phase 2 on Wednesday. We have 2 more regions that are still in phase 1. That's Long Island and Mid-Hudson. And finally, New York City has not been cleared to enter phase 1 yet. Some talk about it being anticipated as early as June 8th, but stay tuned on that. So with respect to everything else except for New York City, all the other regions are either in phase 1 or phase 2 at this point. So the next slide talks a bit about, what groupings we have in each of these industries. We talk about phase 1 and phase 2. Let's just back up a step and make sure we all understand what that means. So phase 1 industries are construction, manufacturing, retail for curbside pickup, and agricultural, forestry, and fishing. In phase 2, we saw a little bit of adjustment to what was originally included in that. We now know it means some additional industries can reopen in those regions we just mentioned that are in phase 2. Those industries are office spaces. So very generally, businesses that have office spaces are now included in phase 2, as well as real estate, essential and in-store retail, so not just the curbside retail anymore. It's been expanded more to in-store and as well as essential retail that was operating. Those are the guidelines that were made available now. Vehicle sales, leases, and rentals. Retail, rental, repair, and cleaning, so places that rent equipment as part of their business, or dry cleaning, for example, those would fall within that category. Commercial building management, and hair salons and barbershops. And if you are someone who is in, a salon or a spa industry, you know that there was quite a bit of upheaval and kind of last minute changes in what services could be provided at the end of last week. So currently, hair service businesses are allowed to operate in phase 2. That includes hair salons, barbershops, and other similar hair service businesses. But things like nail salons, tattoo parlors, and other non-hair cutting related personal care services are not permitted. So everything from beard trimming, nose hair trimming, facials, manicures, pedicures, makeup application, threading, tweezing, waxing, all those other things are not included in phase 2. And that was kind of a last minute change, but that is, make sure you're clear on that now if you're in that sort of industry. Looking ahead, what we think is going to be included is phase 3. We know it should be restaurants and food service. Personal care services might also be in there. That's been a number of the governor's briefings at some places, but other places on the website and New York Forward website, it's not listed as phase 3. So stay tuned on that. I'm not confident that it will or won't be in that phase. Potentially it might be. Phase 4 will be arts, entertainment, recreation, education. So I think we can expect a couple things as we move forward into reopening. One is this, kind of constant refinement of these industries that are kind of subject to change. So keep an eye out on that. These are not something that's set in stone that once you're in a phase one, you're in phase one, and those don't change as we go along. We've seen tweaking of those industries and what's been allowed to open as we move through those phases. So use that lookup tool or contact your bond attorney if you're confused about where you are and what that means for you, but make sure you're confident about that. We might also see that there might be some period of hold after a region completes 2 weeks in a phase. There may be less discretion to the regional control rooms and the local officials as we anticipated. For the 5 regions entering phase 2 at the end of last week, we saw the governor said he had to give the data to these international experts to examine before giving the all clear. It did happen a day later, and there was quite a bit of criticism that he faced for that, and kind of the lack of communication and confusion caused by that. So we'll see if that changes, but that's a possibility that it's not an automatic. Once 2 weeks has passed, we enter into the new phase. So keep an eye for those developments. So the phase 2 guidelines were just released last week, and since that's the new issued guidance, I thought we'd just take a second and kind of talk about some highlights that's in that guidance. In a lot of ways, it's similar to the phase 1 guidance that the state released, the same for those industries. As anticipated, as we advise, you have to come up with a workplace safety plan. It has to meet the certain required components as specified in the detailed guidance is issued by the state. So you need to be aware of those guidelines that are applicable to your industry. You need to have read them. You need to submit your affirmation that you're going to comply with those guidelines. That's done online, so you read through the guidelines, and there's a link to submit that affirmation right online. So easy to do, but also very significant. And you have to post your workplace safety plans in the workplace. You don't submit them, but they need to be posted. So you need to have them, set, they need to be in compliance with the guidelines, and they need to be posted in your workplace. The phase 2 guidelines contain many of the same broad categorical components as the phase 1 guidelines. So they talk about things like physical distancing, PPEs and face coverings, hygiene and cleaning, screening procedures. All of those same types of categories are included in there. The one thing that I've been getting a lot of questions on for physical distancing is this max occupancy rule. 50% of the max occupancy, and a lot of these guidelines we're seeing that is based on your certificate of occupancy for a particular area or building, not 50% of your workforce. And there's been some confusion about that because I think that's the way that the pause happened, right? We went to percentages of your workforce. When we talk about the occupancy rules in these guidelines, you need to know what your certificate of occupancy is, either for your building or different areas of your building. If conference rooms, for examples, and hotels might have different certificates of occupancy. And that 50% max occupancy is based on that. So it's more about the density and less about your number of employees at your actual workforce. For the screening procedures, I know Hermes touched on that a bit. For the first time, some of this guidance talks about, some sort of a definition for close contact. I know some people have been asking, what does that mean? They refer to the CDC's principles on contact tracing for that, meaning close contact is someone who was within 6 feet of an infected person for at least 15 minutes, starting from 48 hours before the illness onset until the person's isolated. So there's lots of specifics there in distance and time. They also say, though, that if it's unclear, contact your local health department. So if you think a person has been, within 6 feet of an infected person for some sustained amount of time, you're not quite sure, err on the side of considering that to be close contact. Again, temperature checks are something that's been permitted for employees, but it's not required. It is one method you may choose to use for screening. I think there's a lot that goes into those decisions of whether or not that's right for your business and how it can be done. Your plan should also include what to do in response to a suspected or confirmed case and how long they must stay out of the workplace. So again, those are all very similar categories to what we saw in the phase 1 guidelines. But what we're starting to see now is a lot more differences based on the industry being discussed. So in phase 2, there's more industry-specific guidelines. So there is a template workplace safety plan that the state has provided. That is the same for everyone. There is no accounting for individual industry in that template plan. So that's a good starting point, but you cannot just rely on that template plan because it does not go into any of these industry-specific requirements that I'm going to talk about in just a second here. So I'm going to take a minute and just highlight some of the, notable industry-specific requirements here. I can't get through everything. This is not an exhaustive list. We could be here for hours if we do that, but I just want to point out some examples of some of the things that are different about these guidelines in a couple of the industries. So first of all, hair salons and barbershops. Again, that's just cutting, coloring, and styling only. Stylists must wear face coverings and face shields when directly providing services on a customer, when they're actually providing the cutting or coloring services. When they're only interacting with a customer less than 6 feet, say like the cash register, for example, you only have to wear a face covering. The face shield is something very different from any other guidance that we've seen, and I think it caught a lot of people by surprise, especially in that industry. I think probably where it's coming from is in response to how close you need to be for a sustained period of time, to someone's face and head to be able to perform that service. And also there's reports that we've seen in other areas where stylists unknowingly exposed, hundreds of clients to COVID-19. So I think that's probably where it's coming from, but that's a pretty dramatic difference from the other guidelines we've seen. The guidelines also require testing of stylists every 14 days. Now, it does specify that's as long as the region is in phase 2, so there may be some updates to that. When you move out of that phase, perhaps that will go away, but that again is another a different requirement that we've seen from other guidelines. Aprons have to be laundered and disinfected between clients. Chairs have to be 6 feet apart unless they're separated by barriers. You need to close the waiting rooms. The 50% occupancy rule applies to both the workforce and the customers in the building. Customers have to maintain 6 feet of separation, and you need to advise them to wear face coverings unless they are under 2 or can't medically tolerate them. That's what the guidelines say. You need to, inform your customers that they should be wearing face coverings. Offices. One thing to note is that the office guidelines also apply to businesses where parts of their business function in different guidelines. So they use as an example, a front office for a construction company. The construction piece of their business, obviously there was the construction guidelines in phase 1. However, for the office portion of the business, if you have a front office portion there, you need to comply with these office guidelines. So that's some pretty broad applicability of the office guidelines that just came out. So be aware of that. A lot of similarities in the office guidelines. It does say you need to modify the workstations to remain 6 feet apart or require face coverings. Advise the employees to wear face coverings in the common areas like the elevators, the lobbies, and when traveling around the office. So that's another difference. Most of the time we see the face coverings come into play when you can't maintain 6 feet of distance, This guideline seems to say, look, if you're going to be in a common area, like in the hallways or in the lobbies, you need to wear the face covering. For real estate, in-person showings can now take place if the property is vacant or unoccupied. Face coverings have to be worn, and you need to be prepared to provide those to prospective tenants and buyers if they don't have them. You're supposed to tell buyers to avoid touching surfaces, which to me is just like the don't touch your face advice. I mean, as soon as people started saying that, immediately I found myself touching my face, 20 times a day. It was all I could think of, which is probably some kind of interesting human psychological experiment and suggestion. But you're supposed to tell them not to touch the surfaces. If someone were to tell me that as I walk into a house, I immediately probably want to touch the countertop and the tile, but I digress here. You got to clean the high-touch surfaces after. Your open houses, you can only have one party at a time. For essential and in-store retail, the 50% occupancy rule applies to both the workforce and the customers as well. So keep that in mind. It's not just your employees. Customers are supposed to maintain 6 feet of separation. If you've been in kind of grocery store lately, a lot of them have that announcement they'll play and signage to advise customers of that, to kind of a constant reminder of that. Except for cash registers, the exception seems to be based in some note of safety of the function, which doesn't quite make sense, but at least there's some acknowledgement that when you come to a cash register, you're not always able and you really can't maintain 6 feet of separation at all times. You also have to advise customers to wear face coverings unless they are under 2 or can't medically tolerate them. Now, the guidance specifically talks about prohibiting you from requesting or requiring medical or other documentation for those who decline because of medical or health condition. So presumably, you can ask or remind people about that, but you can't ask for further proof. You can't ask for documentation about it to prove that it's because of some sort of medical condition. And this to me is a minefield. We've already seen lots of stories of confrontations, ugly confrontations with terrible results happening, where customers are, kind of confronted about this requirement, and some kind of confrontation ensues. So if you're in this kind of industry, think about how you want to remind customers of this, if at all. If you're going to have anyone, actually make a reminder to customers, make sure you know who's going to be doing that, make sure they understand the limits of what they can ask for, and make sure that they know what to do in case of a confrontation or how to avoid those confrontations. Because I think that's a pretty big area where I really can see a minefield in there. So you cannot mandate customer health screenings or contact log, but you got to give customers the option and encourage them to do so. So make that available to them, but you can't mandate them for coming on site. And again, there's lots and lots in this guidance. We could spend hours talking about it. And I know we get lots of questions in these and we can't always get to because there's a number of participants and we're trying to get to all these topics, but make sure you know what industry you're in, you're looking at those guidelines. If you have questions, please feel free to reach out and make sure you're comfortable with them.
Katie, thanks, Katie. A lot of information there. One thing that sort of happened right as we were coming into the webinar today is that the governor announced that summer camps would be open, at least the day camps. That appears to be irrespective of region. We haven't seen any guidance on that yet, so we'll have to look for that. Maybe it'll be in an executive order later today, but it just illustrates the fluidity and the complexity of what we're talking about here, that some of these rules apply irrespective of where you are in New York State. Some are regionally based and then also based by phases. All right, let's go to Jessica Moeller now. Jessica is in our Garden City office, and this is a topic that we've talked about some previously, but as we proceed with reopening and look at getting people back physically into the office in most regions and in different phases, there are going to be accommodation and discrimination issues that employers are going to have to deal with. So Jessica, please take it away.
Thanks, Pete. And exactly. So we've talked a lot over the past couple of weeks, and even longer than that at this point, about reopening and the phases and how this whole reopening plan is going to work. And the reopening is great. Now the question that comes in is, once you're able to open and bring back at least part of your in-person workforce, how are you going to be able to manage that? And in particular, what are you going to do, and what are the cans and the can'ts and the musts and the shoulds of how to handle situations that come up when an employee says, I'm not able to come back to work because of fill in the blank reason. And so, this whole pandemic and the shutdown has, and the reopening in particular, has really brought to light a lot of potential issues and hazards that employers can walk right into in terms of accommodation obligations when an employee says, I'm not able to come into the in-person workforce for whatever reason. So, one of the things that we've already seen a lot of questions on, and we've already dealt with a lot in terms of the planning, is the employees who say, I'm too fearful, I'm too afraid, I'm high risk for either an age reason or an underlying medical reason, and because of these situations, I don't want to come back to the in-person workforce. And I'm needing to stay out, or I'm not able to come in for that reason. So we've gotten a lot of questions of how to handle these kinds of situations. And, it's not always an easy thing to walk through, but, fortunately or unfortunately, there's no clear answer, and you really need to look at each individual situation and treat any kind of these employee requests and accommodation situations on a case-by-case basis. So, let's just take a couple of examples. So when you have somebody who's saying, I'm not able to come to work in person because I'm at high risk, and the reason I'm at high risk is because of my age. I'm perfectly healthy otherwise, but I'm in the high risk age group, and therefore I don't want to come into, or I'm not able to come into work in person. So how do you handle those types of situations? So, the pure age reasoning, there's no special legal obligation to accommodate somebody due to age. Age is a little bit different than if you have an employee who's saying, I'm high risk because of an underlying medical condition, where in the medical condition scenario, you do have legal obligations that come into play for needing to accommodate those individuals. So, there's a little bit more leeway in terms of handling a high risk purely based on age. However, you want to be able to work with your employees. You want to be able to be as accommodating as you can, and you should still engage in that kind of discussion with the employee about ways in which that you can, as an employer, make their workplace as safe as possible and limit the potential exposure to the virus for that particular individual. And of course, you should be doing all of these protocols that that Katie, for example, just went through in terms of social distancing, protecting the office environment and other scenarios. So a lot of the things that you would presumably do or want to do for somebody in that high risk age category, you're likely already going to be doing. Now let's take a situation where it's not just purely age, but it's somebody who has some pushback to returning to the in-person workforce because they do have a legitimate underlying medical condition. Now, of course, for certain employers who are in that size, the 500, fewer than 500 employees, for individuals with underlying medical conditions who have been advised by the doctors to remain out of work and self-isolate, there's going to come in to play some protections under the FFCRA for those particular individuals. But even outside of that, let's say they've already exhausted their, up to 2 weeks, 80 hours of leave for full-timers under that law. If you have a situation where somebody has a legitimate underlying condition and are going to be at higher risk if they're in person in your workforce, you really would need to treat that situation the same, just as you would any other type of accommodation request or accommodation discussion that you would have with an individual who, for example, needed time off for medical treatment. You want to be able to engage, and you really need to engage with that individual in the interactive process to determine what, if any, accommodation can be provided to enable that individual to do the essential functions of their job. Now, for some, depending on the job, the accommodation could involve a continued telework arrangement. There's a lot of discussion lately about returning to the in-person workforce, but of course, for many industries and for many businesses, the past several months, people have been working, and I would guess fairly successfully working in a remote environment. So it may be that providing a continued remote work situation for an individual with an underlying condition, medical condition, is a reasonable accommodation to be provided to help protect that individual. And it's really not an accommodation for the virus because the person isn't sick with the virus. It's an accommodation for the underlying medical condition that you're dealing with. One of the other situations that I've gotten a lot of questions about is, what do you do with a situation where an employee is saying, I'm just too scared to come back to work? Not a situation where the fear is based on being at high risk, not a situation where there's an underlying health reason, or even potentially where there's somebody in their home that has some underlying condition and they want to limit exposure. It's purely based on a fear attached to the hysteria and the unknown relating to this whole pandemic situation. And so, what do you do in those situations? And again, you have to treat that situation on a case-by-case basis. So there's potential that even a fear could rise to the level of being a disability if the fear that the employee is facing and dealing with creates a level of anxiety, potentially a level of stress, PTSD even for some individuals. It may be a situation where the fear that is being experienced and the anxiety that's being experienced is a medical condition, a mental health medical situation that needs to be accommodated just the same as any other physical type of disability. But if you have somebody who, the fear does not rise to that higher level, but is more of a generalized, I'm just too scared, perhaps there's less of an obligation to accommodate that and more ability to require that individual to report in person. So there's a lot of these sort of to be determined on a case-by-case types of factors that are going to come into play to really determine what the outcome is and how much as an employer you can push to bring that individual back into the workplace, or conversely, how much of an obligation that you would have to work with the individual and provide accommodation so that they don't have to come to the workplace, or you might have obligation to potentially modify their working environment actually in the facility in order to help protect them and enable them to do their job. Now, I do want to just touch on one other situation that we're seeing a lot of questions about that are coming up, particularly as we're nearing the end of the school year for many locations, and summer break is going to be coming upon us. And there's, as Pete mentioned, summer camps just got announced that are reopening. So, we've gotten a lot of questions, and I imagine there's going to be continued pushback as we move more forward in the reopening process for employees who are unable to return to work due to child care types of needs. Because, we've seen for the past several months, schools have been closed as a result of COVID, and individuals need to be home watching their kids and helping their kids during those school closures. So, as we move forward in the reopening, there may be more pushback because somebody needs to stay home with their children when the schools are continuing to be closed. So, I will note that a generalized summer break, a generalized, school is out for the summer type of school closure is not going to be something that is going to trigger any obligation on behalf of the employer to potentially accommodate that individual and provide the kinds of leaves that I know we've talked about on other webinars, under the FFCRA provisions. But if summer school is continuing to be closed and the child would be within summer school, or if a summer camp is closed between now and the end of June date when they're going to be reopening, you might still be facing those types of child care needs to be out. And as an employer, particularly those who are small enough to be covered by the federal FFCRA, you're going to have an obligation to accommodate those types of requests being made on behalf of or by the employees. And so, that obligation, although it's not disability related, it's not high risk related, it still is going to be out there, and you're going to need to provide accommodation to employees who are in those scenarios, to the extent that the particular FFCRA would apply to you. And just one other thing that we might see some more of as employees come back into the workplace. There's a lot of rules and a lot of obligations and guidelines and requirements that are put out there in terms of what we need to do to make our workplace safe. The cleaning protocols, the PPE protocols, et cetera, of all the things that we need to do. Now, what if we have a situation where, despite our best efforts, somebody is still making a complaint against us? One of our employees who we've brought back has still filed a complaint against us, for allegedly not following protocols, or they believe the workplace is still unsafe and not compliant, and they lodge a complaint. Well, just like any other scenario where an employee, files a complaint of harassment or discrimination or whatnot, if we have a situation where we do have an employee who has complained, we need to be very careful in how that employee is dealt with. We need to make sure that there's no retaliatory action taken against that individual, because the right to complain about the potential unsafe nature of a workforce is a protected right that the employee has. And so we need to be very mindful and be careful of not taking any type of retaliatory action against somebody who may have lodged a complaint. Even if we are providing as safe a workplace as we possibly can, even if the complaint ultimately is without merit and is dismissed, we are still going to need to not take retaliatory action against that individual for having lodged that complaint. So, these are just a few of the potential issues that we're going to see coming up more and more as we move forward with the reopening phase and getting people back in person to our facilities. But just wanted to touch on a few. And Pete, I'll turn it back over to you.
Jessica, thanks. Two broad takeaways, and it's complex, but some things have not changed much at all. And that is that we're going to deal with these issues on a case-by-case basis. We're going to be looking at individual facts and documentation, individual workplaces. We've gotten a lot of questions here about how we would do this, and unfortunately, it's perhaps a frustrating answer, but it depends on the facts, and it depends on the the employee's health condition, and it depends on the workplace. So that hasn't changed. That's our traditional ADA, New York Human Rights Law, disability type analysis. Age may be a bit of an overlay with the medical conditions, but I mean, frankly, it's a traditional analysis. What has changed, I think, is that we're gotten a little better at understanding what it means to work remotely. We've got the Families First Coronavirus Act, as you mentioned, Jessica, and we've got various sick leave provisions and unemployment insurance relief and some of the other things that may impact what it means if someone can't be accommodated and what rights they have. So a lot to keep on our plate. So the last thing we wanted to talk about today, and we are running a little over, but we wanted to get you a lot today, is kind of the litigation piece and what your potential liability might be. If you look at this in chunks, can we reopen or not? That's what Hermes and Katie were talking about. What are some of the employment issues that are associated with the reopening? That's what Jessica was touching on. And now Jen Schwarzout is going to talk a little bit about, what the liability issues might be and our responsibilities to others and to our employees from a liability perspective. Jen, take it away.
All right. Thanks, Pete. Hi, everybody. Thanks for sticking with us here. So obviously, liability risk is something that I'm sure many of you are contemplating. Much like many of our legal answers, it definitely depends. There isn't an exact answer, but just kind of globally, I wanted to go over a couple of concepts and then dial in on some more specifics that might be interested for all of you. The question of whether you could be liable really centers on what we call concept of duty. And in the legal context, that essentially means that there's a relationship between the parties that requires one party to owe the other party a duty of care. So typical examples would be employer-employee relationships, doctor-patient relationships, commercial business to customer relationships. And the law dictates the various different duties and what that means in the context of those relationships. But it's fair to say that when there is a duty of care owed, and there's a breach of that duty, there's a potential that the injuries that may result from that breach could be cognizable in a lawsuit. And it really depends on the circumstances. There's a related concept called notice. So notice would be whether you knew or had a reason to know that there was a particular circumstance that would, and that often dictates whether you owe that duty. And we'll get into that a little bit further here. Obviously, for those of us on the call that are lawyers, all of those concepts are what is discussed in about a whole year course in your first year of law school. So I've tried to summarize that in about 2 minutes. So moving on from that, if you own or operate a business, the good news for you or an organization is that your liability is limited to those to whom you have a duty. It's not infinite. So let's talk about employer-employee relationships for a minute. As many of you know, in New York State, workers' compensation is typically the exclusive remedy for workplace injuries, bearing very few exceptions that at this point don't seem to apply in the COVID context. So I've confirmed that the state Workers' Compensation Board website has a whole section on employees and their ability to apply for workers' compensation benefits should they believe that they've had a COVID injury or development of COVID as a result of a workplace exposure. In terms of the process, that will be similar to other types of comp claims in the sense that they'd have to have a physician who's certified by workers' compensation, certify that they believe that the injury is related to a workplace event, and then a determination would be made. Obviously, this is not a traditional type injury that you would typically see. So obviously, it's much different than someone slips in your kitchen and they break their arm. And that is a pretty obvious correlation there. This will be a much different thing in the sense that the exposure pathway, in other words, proving that the exposure did occur at work, will be a much more challenging situation, I think, to prove. So in terms of the process, the workers' compensation carrier would make that initial determination similar to other types of claims. And then if that was initially denied, the decision would ultimately be made by the Workers' Compensation Board. And many of you know comp would include treatment for medical payment, potentially wage replacement if time out of work is necessary. And then if there's a death, it would be benefits to the surviving family members potentially. Importantly, New York does not recognize the ability for third parties to sue the employer of a loved one. So by way of example, you employ a husband and the husband contracts COVID, the husband's spouse also gets COVID. The spouse, the law in New York presently would prevent the spouse from seeking recovery to the employer in that circumstance. That is not a legal relationship that's recognized. In other words, there's no duty, going back to that concept, to that third party. And so that is something you would not be responsible for if that occurred. In terms of businesses and organizations, there's a general duty to protect what we call invitees or people that you would have come onto your premises, your office, your store. And the duty there is to guard against unreasonably dangerous hazards. A great example that everyone can relate to is you go to the grocery store, there's a spill in aisle 6, there's milk on the floor. If the store knows that there's that spill and they do nothing, and a customer comes along and spills in the milk, falls down, breaks their arm, then the store can be held responsible for that. However, if this milk spills immediately and the person falls right away, there isn't an opportunity for the store to clean it up. That's a different scenario. So it's really case specific. And it's unclear what is going to happen with COVID. I think certainly it would be important to be able to establish that your store, let's say, or your office place is following the safety protocols. If you disregard those, it's certainly possible, although where we are in the timeline, it's unknown because courts haven't had an opportunity to examine this. But if you have you're inviting customers into your workplace or into your store or into your office, clients coming in, I think it's fair to say there'd be an expectation that you comply with those safety protocols that's been recommended and encouraged by the state. And if you don't, and someone gets sick, it's possible that they could proceed for that risk. Now, we get back to the causation. What would be the causation? They would have to prove ultimately in a lawsuit that the exposure occurred through that particular experience, which could be challenging, certainly based on what we know. But I think it's certainly best practice to minimize your liability risk. The best thing to do is to comply with these safety regulations and protocols and be sure that you're documenting that is being done. So if there is a claim later, you can pull that out and say, no, we did do this, this, and this. And that's always very helpful when you're defending against any potential claim, whatever the case may be. And finally, if there isn't what we say a duty to legal strangers. So if there isn't a relationship between parties, it's very likely that there won't be any duty and you would not have risk, although obviously every situation is different. But that would be the general rule of thumb in the time that I have. So thank you very much. And with that, I'll turn it over to you.
Jen, thanks a lot. I think, one of the, solid pieces of advice here in this area would be to make sure you follow your protocols. A lot of people that are in the reopening phases are going to be affirming that they're following a reopening plan, and that would be something to be careful with if we're not in compliance with what's in those plans. The other thing I should mention before we sign off, and thank you everyone for sticking with us here, is we do have a webinar this Thursday on the workers' comp issues. Bob Snashel, former chair of the Workers' Compensation Board, and Lou DiLorenzo are going to put that on. So for folks who are a little bit interested in taking that into a little bit greater depth, please tune in with us on Thursday at 8:30 a.m. Okay, that's it for today. Thanks, everybody. Please stay safe out there, and we'll talk soon.